In just a few moments, we'll be sitting down with a juror from Karen Reed's first trial as week one of her retrial is completed. Thanks for being with us tonight on Canton Confidential. I'm Glenn Jones. Plenty to follow on this Friday. There was a federal hearing today on the buffer zone established by Judge Beverly Cannoni around the courthouse. A group of protesters have sued Judge Cannoni, arguing the restriction is unconstitutional. A federal judge did not issue a ruling today. We ended the day in Denham with 10 jurors, the same number we started the day with. The judge is aiming to seat 19 in all. While that's going on, Reed's team continues to pursue every avenue to have the murder charge dismissed. Reed is appealing her case all the way to the U.S. Supreme Court. If the High Court takes up the case, it could put the retrial on hold. Closure in this case and justice for John O'Keefe still hangs in the balance tonight. 3 years later, after his body was found on the front yard of 34 Fairview Road in Canton. He was just 46 at the time of his death. Our John Maroney is at the courthouse in Denham tonight to explain where we are after almost one complete week.
No, it's all collaborative.
Karen Reed talking about the jury selection process for her murder retrial. She's pleaded not guilty to hitting her boyfriend John O'Keefe with her SUV and leaving him to die in the snow.
We've already begun the impanelment process. It's going very quickly.
Judge Beverly Cannoni told more than 70 potential jurors about the charges against the 45-year-old defendant, the law and their role if chosen. The faster than expected selection process worries some.
It raises more concerns about whether people are downplaying their pre-existing belief in either her guilt or her innocence.
The group was polled. 92% said they've heard of the case. 60% say they formed an opinion, and 17% say they had a bias either for or against Karen Reed. Each juror also filled out a special survey with questions about the defendant, law enforcement, and media coverage.
That questionnaire is a really good starting point for them to have a really solid information base well beyond what they would have just looking at a normal jury questionnaire.
With jury selection underway, Reed and her lawyers have filed a petition with the U.S. Supreme Court, hoping to have 2 charges against her dismissed, including second-degree murder. Chris Dearborn is a professor at Suffolk Law School.
They don't just take anything on these circumstances. And I have yet to be convinced, frankly, that the legal arguments that the defense are making will carry the day.
They ended the week with 10 jurors. They actually had lost one on Friday, but were able to replace that person. They hope to begin testimony when they reach the magic number, 16. In Dedham, John Maroney, NBC 10 Boston.
To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
Right at that moment, jurors were sent home following the first trial after 5 days of deliberation. Judge Beverly Cannoni declared a mistrial after jurors wrote they were deadlocked. Since then, we've heard publicly from several jurors who said they were only deadlocked on one of the 3 charges Reed is facing and cleared her of murder. And tonight we're joined by one of those jurors who served in that first trial. Ronald Estanislao is in studio with us. It's so great to have you here. Welcome to Canton Confidential. All right, you spoke to Eli Rosenberg, our reporter, last month, and a lot has happened since then. One of those things is that Reed's defense team has appealed all the way to the U.S. Supreme Court, where they will argue that you and the panel you sat on acquitted her of 2 charges. Although Judge Beverly Cannoni has not ruled that, that is their claim. Are you sympathetic to that argument? Because what they're saying is it would be double jeopardy to try her again.
Totally sympathetic, given the circumstances that we did arrive at a conclusion on those 2 charges.
Now, what Judge Cannoni has said, of course, is that that verdict was never read in court. Are you sympathetic to that argument?
Also sympathetic to that argument, given the circumstances that it's a system and it wasn't clear in the process, and we should have made that clear and signed the document.
So someone who has dedicated so much of their life to this trial, I think it was more than 9 weeks that you served on that jury, do you hope ultimately the U.S. Supreme Court hears this case?
I hope in terms of justice, they listen to the argument and go from there. Whether there is a decision made on one side or the other is just dependent on the justice system.
Okay, so another thing that has happened since you talked to Eli Rosenberg is that one of your fellow panel members, who was an alternate juror, Victoria George, who happens to be a lawyer, has now joined the defense team for Karen Read. What's your comfort level with that? Do you have any concerns about her doing so?
I honestly don't have a concern. I don't know from a legal standpoint because I'm not a lawyer. However, I think it's good that she is able to give some sort of information so that it can help the defense.
Right. So one of our legal analysts yesterday said she thinks it might be a good idea to sequester the next jury because there's been so much media attention around this trial. Is that something you've given any thought to? Do you think that's the right move?
I think that's the most appropriate move given the circumstances of what's going on and the potential for essentially there may be some sort of compromise during the circumstances of the trial. So it may be in their best interest of everybody involved to sequester the juror.
Okay, speaking of that point, stay right there because we want to cover one other aspect of this and get our audience caught up on the buffer zone surrounding the courthouse. Judge Canoni last month reinstated the buffer zone, and this time it's bigger. The zone, as planned, would prohibit protesters in the area you just saw. But some protesters believe this is a violation of their First Amendment rights. Today, a federal judge in Boston heard arguments in the case. Our Michael Rosenfield is live outside federal court in Boston. Michael, bring us up to speed.
Well, Glenn, Judge Canoni has expanded the buffer zone around that courthouse in Dedham. Protesters have now sued her over this, and now that lawsuit has made its way down here to the federal courthouse in South Boston today.
Judge Beverly Canoni says the presence of protesters outside the Dedham courthouse, where the second Karen Read trial is taking place, can be intimidating and has expanded the buffer zone so that it's larger than the first trial. The buffer zone in the first trial was about 200 feet. The judge has now added about another couple hundred feet for the retrial, which is just getting underway.
We've actually been pushed down now into the residential area. We don't want to upset the residents. We don't want to disrupt someone's business. You know, they haven't done anything wrong.
Protesters were a regular presence outside the courthouse during the first trial, many of them supporting Read and criticizing the investigation and the criminal justice system.
There's just some stuff going on that I don't agree with, and I think that I have the right to be out there speaking out against it.
4 people have sued the judge, saying she's trampled on their First Amendment rights to free speech.
How the hell does a judge have the right to legislate anything outside the courthouse?
Attorney Mark Randazza says there shouldn't be a buffer zone at all, but his clients are willing to compromise and keep the noise level down.
They just want to be able to stand there with signs, quietly expressing themselves. That's what the First Amendment protects. We're willing to be reasonable.
So no decision was made today. Both sides will have to come back here to the federal courthouse next Thursday to continue to make their case. We did reach out to Judge Canoni today for a comment on this lawsuit, but she declined to make a statement. We're live in South Boston. Michael Rosenfield, NBC 10 Boston.
Michael Rosenfield outside federal court tonight. Thank you. We're back with Ronald Estanislao, a juror from the first trial. One of the other things that you told Eli Rosenberg is that you could hear at times the protesters outside of the courthouse while you were in the jury room. Based on that, do you think Judge Canoni made the right decision to expand the buffer zone to potentially prevent something like that from happening in the second trial?
I think it's good to make sure that the jury is able to deliberate and is free from any distractions. That being said, that may be in the best interest to, again, kind of have a larger buffer zone.
Right, and you believe the buffer zone does not infringe on the First Amendment rights of the protesters?
I honestly do not, because they can continue to protest, but it just means that they're at a farther distance from the courthouse.
Okay. As you think about this next trial for another jury, what's your best advice for them?
Listen to the evidence, ask questions, and make sure that you have clear direction from the system. Because if we had that clear direction in the first trial, we might not be in this position today.
Did this trial in any way shake your confidence in law enforcement?
Honestly, I think in every aspect of life, there are people who may not be the best people. So I did not necessarily say that it has affected my thought of law enforcement. There are good people and bad people in every aspect of life. So,
all right. Ronald Estanislao, so great to have you here with us. Thank you very much for being here on Canton Confidential. Up next, an issue that shocked people in the courtroom during testimony last year. And it's a problem that apparently extends beyond the garage at Canton PD. That's when we come back.
Did you see any indications of conspiracies, cover-ups, or corruption?
No. While we found deviations from policy, none of them were intentional, conspiratorial, or with the intent to manipulate evidence or distort findings for trial purposes.
That was last night in Canton. Independent auditors who examined the Canton Police Department explained their findings to the town's police audit committee. The public, who called for the audit, will be able to comment on the findings at a special hearing tomorrow afternoon at Canton High School. Auditors dug into many things, but one area that really shocked us when it happened, video that was inverted when it was played in court. You'll remember the inverted Sallyport video and the clues that gave it away. The image on the bottom is how the garage and Karen Reed's SUV appear in reality. Jurors, unknowingly at first, were shown a mirrored image of what was actually taking place. Well, it turns out this isn't the only camera in Canton that is doing this. The audit found more than one of the town's public cameras record in a mirrored fashion. So apparently nothing nefarious there, according to the auditors. We're joined in studio tonight by Todd McGee, a security expert and law enforcement expert as well, a retired Massachusetts state trooper. So you must remember that moment from the trial. It's something that we talked about around this table. When it happened in the courtroom, it was very, very shocking. The auditor explanation seems to make sense, but it doesn't inspire confidence. How does Canton PD get confidence back?
Well, this audit of the police department was the first step in trying to make that change and that adjustment, trying to bring back the public trust. Really have to tip our hats to the community to bring about this actual audit. And I think the auditors, they had a comprehensive 206-page report that they put together. I think by and large, it was reflective of what's going on within the police department. And the recommendations were not shocking, from what I could tell from looking through and reading through some of the recommendations. But you know, in order to have a contemporary police department, you've got to provide training, education, and resources for the police officers to do their job. So
we also remember very poignantly from this trial red Solo cups and stop and shop bags used to collect evidence. The recommendations that you're talking about should correct that kind of thing from happening again?
That's correct, 100%. There were procedures that were not followed that were identified within existing policy and procedure. That being said, a lot of the policy and procedure was outdated. There was, in the report, it referenced a policy that was 2013. Policies should be updated frequently. Even if there are no changes, at least you're confirming that that policy is still in alignment with contemporary policing practices. So those types of recommendations in order to go through the existing policy within the department, making sure that everything is up to speed, up to standard, in alignment with their accreditation that they have as a department, as an agency. And that way you can then marry up the training, the education, to make sure that police officers are prepared to do their job.
So many of the people watching right now, Todd, will live in a small town and have a small town police department. Is this in some way a warning to them to be proactive about these issues because they might appear in their police department too?
What was interesting about the response from the auditors is that they said that there are some jurisdictions that have 3 murders by lunchtime. Canton's not one of those communities. Yes, there are 3 incidents that are under investigation currently. However, you, as a small town with a small police department, you want to get out in front of these things. It only takes 1 incident to bring unnecessary exposure to your agency. So better to get out in front of things, better to learn from other people's mistakes.
All right, Todd McGee, thanks very much. All the evidence, mishandling inverted videos, none of that is part of what we're going to be talking about next. Local attorney Morgietta de Rissiere will join us after we take a quick break.
Obviously, this could have an impact on the trial date if you appeal further. If this judgment is against you, how far do you intend to take this?
I'm hopeful that the judgment is for us and it's the state that's doing the appealing rather than us.
Are you concerned there is no precedent?
The appeal that day in Boston did not go the way Karen Reed's team had hoped for. That's Martin Weinberg, who's leading Reed's appeal. The appeal had already been denied at the state level, and the federal judge who heard arguments that day denied that appeal as well. Now, the Karen Reed case could be heading to Washington. We're joined again by attorney Morgietta de Rissiere. You were here last night giving us that instant analysis on the Supreme Court filing. And then when I was thinking about this more at home, I was remembering that when I run into people at the grocery store, at a Celtics game, they really want to talk about the allegations of police corruption in this case.
Right.
The U.S. Supreme Court filing is silent on that issue. They want to talk about double jeopardy and whether the defendant's constitutional rights are being infringed upon. Can you talk to me more about that legal argument? What is it that they have to prove?
So again, it's the same argument that they've been making all along. I want the viewers to really understand it's not a new argument. They're just using all of the resources that they can. But essentially what they're arguing is whether or not they have enough to move forward to retry two of the charges in which Karen Reed's team believes she was already acquitted of, because there were jurors that came forward and said, essentially collectively, that they already voted on those. And so if they truly did vote on them and provided an answer, which they're saying is an acquittal or not guilty, why retry her again? And I think that's what the issue the Supreme Court has to decide. Again, piercing into that sacred juror deliberation, which is, again, an uphill battle. There's not a lot of case law that supports it. So Karen Reed and her team are taking it all the way.
And importantly, one of the two charges that you're talking about is murder. So
Right.
That would be the most serious charge that she faces.
Absolutely. And again, she's being retried for the same, 3 counts, right? I think last year when we went through this, a lot of people thought that, maybe they would make amendments to the charges or maybe drop some of the charges, but we're here with the same charges. But yes, one of the charges is murder that they're trying to see if they can get off of the list at this point.
So one of the reasons I think you were telling us perhaps the Supreme Court decides to hear this case is because it's so unique that you would have a mistrial declared and then the jury, multiple jurors, come forward to say, actually, we acquitted on a couple of these. I'm not sure the High Court has ever faced a case quite like this one. Can you think of any?
I haven't. And I think not only does it have to be a unique set of circumstances, it also has to affect a lot of people or have affected a lot of people. And we don't know. This is a case that's highly publicized, so we're hearing about it. And maybe there are other cases where this has happened similarly. I think the hard part is that they hear so many cases, and the chances of it actually coming before the Supreme Court is really, really low. But the interesting facts that surround it could be enough that they might want to just take a look at it.
All right, so let's kind of game this out. If the Supreme Court has not made a decision about whether or not they will hear the case, do you expect that to delay the trial in any way? Or could only their decision to hear the case delay the trial?
Here's the thing. We still have to remember at the end of the day, the trial has to move forward. They've already started picking jurors. They have the dates already in place. It's great that they're moving a little bit quicker than scheduled, but the case has to go on. So if the Supreme Court doesn't intervene, and they may not want to get into the nitty-gritty of this lower court and their situation. So if they don't intervene, the trial has to go on.
Wow, I can't believe we're here.
I can't believe we're here
and
either.
Consistently surprised by every single development in this case.
Absolutely.
Morgietta de Rissiere, thank you very much.
Thank you.
We'll be right back. We will be answering your questions again this trial. We read hundreds of them last year, and we'll try our best to answer them all again this year. You can send us your questions for the experts at Canton.confidential@NBCUni.com. Also remember, NBC 10 Boston is your source for everything related to the Karen Read trial. Don't forget to tune in weeknights at 7 for a full recap of the day's court proceedings right here on Canton Confidential. A lot to look forward to in the days and weeks ahead. Tomorrow, the Canton Police Audit Committee will be before the public to hear their feedback on that report. Next week, more jury selection, jurors seated, 10 so far. We're trying to get to 16. And then in the days after that, we'll find out if this case is heard at the U.S. Supreme Court. Thanks for joining us tonight. I'm Glenn Jones, and for J.C. Monahan, we hope to see you back here next week.